Okay, the defense attorney going after the credentials of this individual who has a lot to say. I don't know how you're going to really argue his credentials when you're talking about facts in terms of the x-rays, the fact of where that bullet was.
Corroborated by the medical examiner, Dr. Hurst.
Let's bring in our guest to give us a little insight here from Denver, Colorado, criminal defense attorney Colleen Kelley. This is a weird case. Colleen, everybody, family thought it was suicide. She was suicidal. The person at the weed store, even reported it, saying this woman is suicidal. They find her dead. What's your overall take, and what stands out?
Well, that is my overall take, that this is a very strange case. And initially, the judge asked the question that I've been asking, right? That clarification that there's a bullet inside her abdominal cavity, and how that got there. It wasn't swallowed. It was, they're asserting, inserted after death. But certainly this is the expert that they've brought forward to say this was definitely not a suicide. And so the defense attorney obviously has to attack his credentials and to show that he's not necessarily qualified to make that determination about whether this was a suicide, whether this was a homicide, whether this was an accident or natural causes. But certainly his observations have to be respected. He is trained in that regard.
Certainly, and let's talk about the fact that we're not in a trial. We're not with a jury with beyond a reasonable doubt. This is a bond hearing. What are the different levels when we have this in front of a judge trying to get an idea of how to move forward with this case?
Right, and I think I heard you comment earlier that you don't generally cover bond hearings. It's because they're frankly generally boring. They address whether the person is a flight risk and whether they're a danger to the community. Now, this is a different case because it's a homicide case. What they're doing here is they are having basically a mini trial to see if there is proof evident presumption great. That's the standard in Colorado, and I think it's the same standard in Oregon, where they are trying to argue that this person that he should be denied bond because the evidence is so great against him. So that's why they're going into these details about the manner of death, the circumstances surrounding finding the body, and then connecting it to the defendant.
Absolutely.
And the part of the equation, I'm sure, for the judge is also the significant manner of the evidence in terms of the depravity, possibly, and the bullet. If the judge was questioning this expert, because to your point, as soon as he asked the question, I was thinking, yes, thank you.
Yeah, he seemed to be hung up on it. He was shaking his head even after getting the answer.
So now the odds of the judge, who we watched him in real time, absorb the information, shake his head, and realize, oh, God, I don't think this guy's getting out on bond.
Yeah, probably at this point.
What do you think?
Well, those are the reasons why a judge would deny bond. And remember, the right to bond out, the right to bail, is generally thought of as a constitutional right because you're presumed innocent until proven guilty. So that's why they have this different type of bond hearing in these circumstances. And if the judge finds that there is proof and a greater presumption that he did commit these crimes, then you can see why a judge would deny letting this person out on the street. Because if you are someone who would do something like this, regardless of the presumption of innocence, the judge is going to presume that he's a danger to the community.
Colleen Kelley, thank you so much for that analysis. We're going to get to a break. When we come back, we'll have more of the bond hearing, but also we get a live report from Matt Johnson. He's been monitoring everything that's happening out in Utah on the Charlie Kirk suspect who was arrested today. Tyler Robinson, stay with us. More ahead. Matt Johnson, thank you for that report and update. Let's bring back in criminal defense attorney Colleen Kelley, an attorney who is just following this news with us. Colleen, this has been really difficult to watch play out, especially for young people who were supporters of Charlie Kirk, who watched this happen there at the Utah State Valley University, and then to know that this defendant is a 22-year-old. Can you talk about the age impact on this case?
Well, I think that we've seen a lot of shootings, including school shootings, that involve very young people. And I'm talking about the shooter here. But obviously, I don't know that it matters what age you are. No one needs to watch that. And regardless of how you feel about someone's political views, you can't shoot them for it. So I think this is obviously tragic, and even more tragic that these people had to witness this. But I do think that it seems like they found the one who did it. There's significant evidence tying him to the shooting, and hopefully they'll uncover even more in the coming days.
Take us through the legal process in terms of, you've got the feds who are obviously involved, and they can easily make a case to come in and take jurisdiction through a terrorism, even just using the similarities to Mangione with the bullets. They could use it. They've got many tools to take this case. And then the state of Utah. Both avenues have, at the end of the day, the death penalty. What goes into that decision making, and who do you think is going to take the lead here? They did mention in that presser today that Erica, Charlie Kirk's wife, will be consulted and be part of this process in terms of determination. What's your take? What's your gut tell you on how it's going to proceed from here?
Generally, I think this is something that would be a federal case. That's usually when they step in, when it's a public figure, when it's a political figure, when it's something that so many people are exposed to and are watching. And frankly, they're going to have better resources and more resources to pursue this, to gather the evidence correctly, and have an airtight, nailed down case against this person. They want him in federal court, I think. That's what we're used to seeing anyway.
That confession that he made to his seemingly either his parents or to a friend, and then it came to the parents. Are there any questions about whether or not those will be able to come into court when you're looking at this from a legal standpoint? There's a lot of things that have been said, and we don't know if he's going to say the same thing to police. Do you even think they're going to get a chance to interrogate him, or is he immediately going to be given an attorney?
Well, the odd thing about this case is there's so many things, seemingly right now at least, that point to him wanting to be caught. He wasn't trying to get away. He's putting inscriptions on things, tying them back to him. He's messaging a friend about the plan as far as how I'm following it. He's making a confession to people. This isn't someone who wants to get away with it. And when that happens, we usually don't see them requesting an attorney right away. They are happy to tell their story. So I'm not sure. I'm really excited. I'm interested to see if he requests an attorney. No one can force an attorney on you, but of course you have the right to remain silent. So in the coming days, I think that will come out.
Yeah, it's a good point. And there's a chance that he jumps off of that roof and he's like, wow, I can't believe I haven't been arrested yet, and then just kind of gets away with it. And the way that it played out, he was a free person for 33 hours, is how long it took. But you knew that they were going to get him. It was just a matter of time.
Yeah.
And a family member, in this case his wife, Erica, how much power do they have in terms of a decision when we're talking about yes or no to the death penalty, typically in a case where that is being contemplated by prosecutors?
I think that depends, and I've seen it both ways. I've seen it where a family has pushed very hard for the death penalty when it used to be available in Colorado. It is no longer. But I've also seen prosecutors within the state of Colorado pursue the death penalty when the family was adamantly and vocally against it. And frankly, the particular case that I'm thinking about, the family opposed the death penalty because of their personal religious views. They did not believe that they wanted to be part of someone else's death after the tragic death of their family member. So no one has to leave the decision to the family, I guess is what I'll say. They're not going to leave that decision. They're going to make their decision ultimately on what they think is best for law enforcement, for the country. And frankly, I think to make people feel better about what happens when you are shooting someone for their political views. And frankly, the fact that it is increasing in late years, I think they do need to show force in cases like this.
Yeah, certainly this is one of those cases where a message will be sent. There's going to be a lot of pressure on all ends for that to take place because violence never the answer. And this has just been a really tough case to follow.
Yeah, and again, political, it doesn't matter where you are on the political spectrum. Universal disgust should be the reaction to this scenario that we saw play out in Utah. And we'll see. They have 3 days to file, expecting early next week, likely Monday. We'll get more information on where this is going, first court appearance, et cetera, et cetera. Let's get a break. When we come back to Oregon, more of this Gerard Norman bond hearing when we return. All right, we'll get a break first. Colleen Kelley, one more time. This we're just talking here. That was a good back and forth with the defense attorney, bringing up the fact that, all right, let's say you see your loved one hanging and she's been up there for 5 minutes, pull her down. Now the lividity isn't necessarily in the extremities, it is in the back, and that's where it was in this case. It does seem as though this is not going to be a slam dunk at trial because it is so odd on so many levels.
Exactly, and this is the witness, remember, that's saying this is not consistent with a suicide, but the defense attorney also has just had him admit that it is consistent with Jared Norman's version of events, which is she was in there for about an hour. They finally got in there. They found her hanging, no way to tell how long she had been dead at that point, and they immediately took her down. The father says he undid the rope, and she's laying on the ground, and the lividity or the blood pooling is exactly where he would expect it to be in that version of events.